Honorable members, sorry for the inconvenience. Technology is troubling us,
Recording in progress.
but I'm happy we are getting there. I welcome you, honorable members, to the resumption of the hearing which started yesterday. Are there any apologies? Our staff members?
No apology, Chair.
Thank you. Honorable members, in the absence of apologies or proceeding, today we intend to cover the following areas: resumption, cross-examination of the witness by the advocate of the affected members, re-examination by the initiator, questions for clarity by members, opportunity for the legal team of affected members to call his witnesses, cross-examination of witnesses of affected members by the initiator, re-examination of the witnesses by the advocate of the affected members, questions of clarity by the members. So I will now request Advocate Kasimoto to proceed with his cross-examination. Today I have allocated time. Yesterday, both of you, I gave you ample time, but where we are now, we've got a picture of what is happening. So the allocated time, Advocate, is 15 minutes. You may proceed with your cross-examination to the witness.
Good morning, Speaker, and good morning to the members of the committee. I take it, Chairperson, you are suggesting that you're confining me to 15 minutes of cross-examination. Am I understanding you correctly?
It's exactly because we are continuing. Yesterday, it was because of time we should have concluded this process. So proceed.
Indeed, Chairperson, I just wanted to get clarity, and my understanding is we are set to run with these processes up until Thursday. I was not under any impression that I was confined in terms of how long I can cross-examine, but I will take the instruction and I will, by all means necessary and possible, try to confine me to those 15 minutes. I thank you, Chair.
Advocate, I believe you may request the chairperson to add if you feel and think that you have still have got more, but there is no way we can move without any timing. We are applying rules here. We need to time. If I don't do that, yes, we are to be here for four days. I don't dispute that, but let's try to be professional by making sure that we give ourselves ample time to do whatever we want to do, but we must consider that there are still other parties who are supposed to participate. So if the chair will just say, yes, let's proceed without any directive, it might create problems to us. So if advocate feels that the 15 minutes is little, is upon yourselves to indicate that to the chairperson rather than to say you don't expect that. Thank you.
I note your ruling, Chairperson, and I thank you for it. Good morning, Mr. Klaus.
Good morning, Advocate.
When I put questions to you yesterday, you will recall we had a discussion around the question of, well, the proposition I put to you was that one can't be found guilty of contempt without proving an element of intent. Do you recall that question?
Yes. Yes, I do.
Do you recall what your answer to me was?
I may have said something like the committee will make that determination, but I'm happy to be reminded.
Yes. And then I'd asked you as well whether you accept that intention is a requirement to prove contempt. Do you remember what the answer was to that particular question?
Chair, I may have said something similar to what I've said now. But as I say, I'm willing to be reminded.
Okay, I don't want to misrepresent what you said, and I'll give you an opportunity yet again, and I'll tell you why. I was concerned about your answer to me because you are the legal advisor to this house and to the speaker and to the application of the rules. And your answer to me to that question bothered me. And when I say,
Chair. Sorry,
Yes,
Chair. May I just-
yes, initiator.
Thank you. May I just object and clarify something? Mr. Kaso is not the legal advisor to the National Assembly or to the Speaker.
Thanks.
My learned friend erroneously put that to him, and that is not correct.
Mr. Klasso, who do you advise?
I advise the speaker on matters of the rules, parliamentary procedure,
So you advise the speaker on procedure and the rules, which is a subject matter here.
the rules.
Yes,
I'm not a legal advisor to the speaker.
yes, you advise the speaker.
Yes, I advise the speaker.
Yes. Now I'm saying to you, there's a concern for me.
I'd advocate the interjection by the initiator. I think it is in order. She has clarified that he's not a legal advisor of the speaker and has outlined his role. So if he may proceed along those lines, it will assist us. Please.
Thank you, Chairperson. I withdraw my question and my insinuation and suggestion. Do you advise the legal, the speaker?
Advise the speaker.
Yes. So I use the word you're a legal advisor to the speaker. You're saying you advise the speaker.
I advise the speaker, but I think the
Yes.
point is important. I'm not speaker's legal
Hold on,
advisor.
hold on. I'm asking the questions here and I'm directing where we're going. You are saying verb, you advise the speaker, not noun, you are a legal advisor. That's what you're saying.
Chairperson, I advise the speaker
Yes, yes,
on matters of procedure.
yes.
Yes.
Yes, so you have a role of advising the speaker in relation to procedure.
Yes.
Yes, now we're back to where I was starting. It's of concern to me that you advise the speaker and you do not know or are not prepared to commit to what the test is for what my members are charged with. Do you have a comment for that?
Chairperson, the point I'm making is that will be for this committee together with its legal advisors to deal with the matter. And that's my response.
Yes.
Chairperson, and may I also just be given the opportunity to raise the following issue as well.
Yeah. You are at liberty to can do that, initiator.
Thank you, Chair. I did not want to unnecessarily interrupt my learned friend yesterday when he similarly posed the question to Mr. Kaso about where the intent was a requirement for content. He raises the issue again, and I feel compelled to object now. And Mr. Kaso is correct. It's up to the committee ultimately to determine whether the members accused are guilty of contempt of Parliament. And that is a test that the committee must apply. First of all, the committee must determine the test, and then the committee must apply the test. It's not up to Mr. Kaso or any other witness for that matter to express a view on whether there was intent or to express a view on the legal test. Thank you, Chair.
Thank you, initiator. Advocate of the affected members, can you assist us by cross-examining Mr. Kaso as the secretary based on what he has witnessed and what he has observed during that particular day. That is the role of the committee, of course, can make any determination. It will assist us because members are still going to cross-examine him. Thank you.
Thank you, Chairperson. If I just may, Mr. Kaso testified that his role is to advise, well, he advises the Speaker. I specifically asked him if he advised the Speaker in relation to proceedings that happened on the 30th of August last year. His answer was yes. He went further than that. He says the reason the Speaker made this decision is because of the advice that I give to the Speaker. All I'm simply saying, and what I'm getting at, is this. The charge sheet that has been presented against my clients would have been informed by the advice that Mr. Kaso would have given. And I'm saying, on what basis then does he give the advice to charge my members for willful contempt if he does not understand the test of contempt? Now, I can't get an answer to that outside of Mr. Kaso because he would have had the state of mind as to why he gave that advice. And that's the point I'm simply trying to get at, Speaker. I accept your ruling and I will proceed, and I do not want us to belabor the point. I just wanted to put that on record. I accept your ruling and I'll move on that basis. Let's then move on, Mr.
Sorry,
Kaso.
sorry, Madam Chair. With your leave,
Yes.
may I respond very briefly?
Yes, initiator.
Thank you, Chair. I accept that my learned friend has accepted that he needs to move on, and that I'm comforted that he has accepted your ruling. But just for good order and for record purposes, it was not Mr. Kaso's decision to charge the members for contempt of Parliament.
Thank you, Initiator, and thank you, Chair. We exhausted the point that ultimately the the Speaker made the decisions yesterday, didn't we?
Yes.
So there was no dispute as to who made the decision because you confirmed yesterday that the Speaker makes a decision, you made advice. We exhausted that yesterday, didn't we?
Chairperson, we exhausted the fact that in the House, the Speaker makes decisions.
Yes.
And of course, I advise
Yes.
in the House. And I think, Chairperson, it's important, as the point has been made, to draw a distinction between this committee and the House. Thank you.
Thank you, Mr. Kaso. Let me just take you to Rule 77 if you've got access to it.
Yes, I do, Chairperson.
I'm just going to read it into the record for your benefit and the benefit of this committee and the chairperson. The rule is labeled grave disorder. It says, in the event of grave disorder at a meeting, the presiding officer may adjourn the meeting or may suspend the proceedings for a period to be stated by him or her. Your testimony yesterday was that because there was this disorder on the day and it was of concern to the Speaker, hence she made the decisions she made. This was an option she could have gone for, isn't it?
Yes, she could have gone for this option if the situation had called for that.
Yes. And in fact, she has invoked this rule before, hasn't she?
Yes, she has invoked the rule before.
Yes. So the instances where if for one reason or the other, she couldn't make a ruling on the spot and she wanted order in the House, she could have invoked this rule, couldn't she?
Well, she could have invoked the rule if she felt at that point that she could not deal with the situation. But in this instance, she felt that she could deal with the situation and she dealt with the situation.
No, but see, you're doing it again where you're speaking about the state of mind of the Speaker and you said to me specifically, you can't speculate. Do you know for a fact that's what she was thinking at the time?
No, because she did not invoke the rule. And that's what I can understand to have happened on
Yes,
the day.
that's what
Yes.
you're speculating.
That's what I
the word.
understand to have happened on the day.
Yes.
Sorry, Chair. And really, I don't want to constantly interrupt my learned friend, but Chair, may I speak?
Yes, you may
Thank
speak,
you.
initiator.
Thank you. See, and this is just to be fair to Mr. Kaso as a witness. My learned friend posed a very specific question to Mr. Kaso. Could she have invoked the rule? Mr. Kaso then responded as appropriately as what he could in the circumstances. And then my learned friend then accused him of, but how can you say that? You are now speaking to the state of mind of the speaker. But yet he posed the very question, could she have invoked the rule? So that is not fair to the witness. Thank you.
Advocate, can we proceed and cross-examine Mr. Kaso on the evidence he gave before this hearing, based on the footage and everything which happened, which led to this hearing? It will assist honorable members to be able to take a particular determination, rather than cross-examine him as if he is a speaker. Can we please follow the evidence he gave and cross-examine him along those lines? Because even myself, I'm not a legal guru, I'm not an initiator, but I feel it is not fair to Mr. Kaso, because it seems as if Mr. Kaso is now a speaker and he must behave and act on behalf of the speaker. He gave evidence, he gave what he saw, he gave what everyone see. So can you please assist the committee by cross-examining him on the evidence he gave in relation with the footage of what transpired during the 30th of August? Thank you.
Thank you.
Can I come in?
Chairperson?
Oh, Honorable Chair, can I come in? You are speaking to Honorable Kaba.
Honorable Kaba, you will have your own time. Can you cool down, all of you? Allow me to lead the process with the initiator versus a learned friend, please.
Okay.
But Chair,
Thanks, Chair, for your guidance. Because, I just said,
Proceed or advocate, please.
but Chair, this is Brenda. Chairperson,
I have made a ruling, honorable member. Can you allow me to chair this session, please? You will have your time. According
but
to
Chair,
the focus
no.
hearing, you will have your,
But
don't
Chair, the
distract
way you
me.
are,
No,
the
this
way
is
you are,
hearing. It's not the National Assembly. Can we respect this session? Can we
no,
respect
I
this
get
process?
that. I get that,
Yes,
but the way
I
you
have
are just
ruled,
you
honorable
cannot hold
members,
that
you will get your
the
time.
speaker is speaking with behalf of the speaker, which you denied
Honorable
her to
members, you will
come.
get your time. This is not a National Assembly, it's hearing. Can we all calm
I
down?
never said it's a National Assembly. I never said
Please.
it's a National Assembly.
No,
But you
I
cannot,
have ruled
you
out.
cannot be guiding her.
Can you stop? Can you stop? You stop there. You stop there. You have got your legal advisor. Advocate, can you proceed, please?
I gather that my client has been muted. Is that the case, Speaker?
Advocate, I didn't order anyone to be muted. I have just made a ruling. We are not there.
Thank you, Chair.
Thank you. No one should be muted. Let's allow members to participate, but members, let us respect this session. Thank you.
Thank you, Chairperson. And I just want to place on record that as a matter of principle, I have difficulties with being told that I can only cross-examine on evidence-led. That's not the standard for cross-examination. But I take the ruling and I will proceed on that basis. Mr. Kaso, where we were is the speaker could have invoked Rule 77 to deal with the issue, not so.
Chairperson, certainly, because the rule says the presiding officer may adjourn the sitting, so could have.
So in other words, if she was concerned about the interactions between Mente MP and Mkweba MP and Hlomo MP, and if the allegation is that that caused disorder and she wanted order in the house, particularly in an instance where she has not established the facts of what Mente MP had said, she could have invoked this rule as a matter of principle, not so.
My response, Chair, is that the speaker could invoke the rule if she makes that determination at any point when she believes that the invoking the rule is warranted. That's my.
Yes. Thank you very much, Mr. Bass. If we can then go to Rule 79.
I am the Chairperson.
I'll read the rule into the record and I'll start with sub rule 1. It says subject to 78. A member may speak only when recognized by the presiding officer during the proceeding of the House. We accept that. Correct.
Yes.
And then under sub 2, it says subject to 1. A member may draw the attention of the presiding officer to a point of order or a question of privilege at any time. Do you accept that?
Yes, I accept that.
So it's a matter of principle. There is no allocated session for points of order, is there?
There is no allocated sessions for points of order. However, because I have to respond, you should not look at the rules in isolation.
What am I getting at, Mr. Klaus?
I have no idea.
Precisely. So that's why I always invite you to listen to my question and just specifically answer my questions.
Chair,
What if what you're referring to has nothing to do with where I'm going?
Chair, I am responding to a question, and I'm sure advocate does not expect me to respond the way he wants me to respond. I respond to the question in a manner I believe is appropriate.
Well, that's fair enough. And if that's the impression I created, then I withdraw. That's certainly not what I was suggesting. I therefore withdraw.
Thank you, Chairperson.
So then subsection 2 says at any point you may raise a point of order. Do you accept that?
Yes, I accept that.
In other words, at any point, Mr. Keza could have raised a point of order, isn't it?
At any point, Mr. Keza could have raised a point of order, and it's up to the speaker whether to take that point or not.
But as a matter of principle, at any point, he could have risen a point of order.
Any point, a member could raise a point of order, and the speaker is the one who must decide how to deal with that matter.
Yes. I want to take you to, and of course, we accepted yesterday that Mr. Keza attempted to raise a point of order multiple times, not once was he acknowledged by the speaker. Do not qualify with the reason as to what informed the speaker, because then we're going to get into a debate of how you know. I'd rather you answer me directly. At no point did the speaker acknowledge Mr. Keza MP.
At no point, according to the record, was he acknowledged
Yes.
in terms of what he had asked for. Yeah.
Yes.
But of course, when he raised a point of order, the speaker attempted to listen to him.
Let's then move on to the question of, let me start here. You would have been in one form or the other involved in advising the speaker about these proceedings, not so?
Yes, I was in the house on the day and I advised the speaker.
Not only were you in the house, the day after the 30th of August, there was a meeting convened to discuss this issue, and a report was presented by the speaker, or at least a report by the speaker stemmed from that meeting, correct?
A report by the speaker was presented to that meeting.
Yes. And it's that report that led to these charges, not so.
It is the action of Honorable Beza, which was then part of the report that went to that committee, which the committee deemed, by the way, a multi-party committee, deemed should be referred to the Rules Committee, which is again another multi-party committee. And they deemed it necessary for that matter to come before this committee.
Yes. So the charges would have been informed by that report, isn't it?
The committee would have studied this committee. And I think, Chair, this is another point that is important for me to make. The speaker did not charge these members. This committee is the one that deemed it appropriate to charge the members. All that the speaker did was to rule in the House and to explain the circumstances that led her to rule in the manner that she did. Thank you.
Yes. And I thank you for that. Yes, you're right. And what would inform what charges are competent in terms of the rules falls within your province, doesn't it?
No, it falls within this committee, and I'm not involved in advising this committee.
Let me rephrase the question. I am saying as to whether a member is in breach of the rules, that falls within your province, isn't it?
Certainly, yes, Chairperson.
And that's what I'm getting at. And if a charge is being brought against a member, it's in your province to assess whether there was a breach or not. I'm not talking about what processes should be undertaken as to which body should make a determination of whether they're guilty or not. I'm asking you a different question which relates to your functions. And I'm saying, if your function is to advise on procedure and the rules, then it surely must be within your province to advise as to whether there's a breach of a rule or not so.
Chairperson, in the House, it is my duty to advise whether there was a breach of the rules or not, which I do to the best of my ability.
And I don't question that. And I actually believe that as well. And I'm saying then whether a member is in willful contempt is something that falls within your province, isn't it?
Chair, during proceedings of the House does not make a determination on matters of contempt. I think that point is important. It is for this, when the speaker refers a matter to this committee, she refers the matter to say the committee must make a determination whether the issue presented by the speaker constitute contempt. It is therefore for this committee, not the speaker, to make a determination whether a matter constitutes contempt or not. And in fact, these proceedings are just part of that process to make the determination. Thank you.
I accept that. I'm asking you a different question. I'm saying to you, you advise on the rules and procedure. The question of whether there's a breach of the rules and procedure falls within your province as a matter of principle, yes or no?
Precisely, it falls within my province.
Whether a member of parliament has breached a rule falls within your province, yes or no?
That is correct, Chairperson. It
Yes.
falls within my province.
Whether someone was in willful breach of the rule falls within your province, yes or no?
Willful breach falls within the province of this committee.
No, I'm saying the question of whether a member, forget who you're advising, it's within your competency. Whoever is asking you for advice, because that's what you provide, assume the proper person whom you report to asks you the question, was there willful breach here? That would be within your province to answer yes or no.
It would be within my province to answer that the appropriate structure must make the determination as to willfulness.
And if
What I would, with your indulgence, what I would advise is that the member has breached the rule. And then this structure must deal with the issue of willfulness or otherwise.
Okay. Okay, now we get to somewhere. You saying it's within your province to make it or to advise whether there was a breach or not, correct?
Yes,
But it's not within your province to advise whether it's willful or not.
it is within the province of this committee to make that determination.
Yes.
Chair, to assist the process. Rule 10 says a member who willfully fails or refuses to obey any rule or order or resolution may be found guilty of contempt of Parliament in terms of the Powers and Privileges Act. Now, it is this committee, Powers and Privileges Committee, that must interrogate that issue and decide whether this act has been breached or not breached.
Is it within your province to advise whether a charge whose definitional element requires willfulness is sustainable or not?
It is not within my province to do that.
If someone asks you whether a member is in contempt, you accepted that you can advise that yes, they're in contempt, yes or no?
No, I don't advise. I would not. It would be improper for me to make that determination because it is for this process. After this process which is being followed here to make that determination.
Yes. So if the relevant person, let's assume it's the speaker, takes the view that Mente MP breached the rule, I must then evict her. You testified as much yesterday that there was a breach of the rules which justified them being kicked out of the house, not so?
Yes, I did. And I still do.
Yes. So in other words, your testimony yesterday was that Mente MP acted contemptuously, wasn't it?
Sorry, Madam Chair. May I
Yes,
again?
Initiator. Yes, you may come in.
Thank you, Madam Chair. May I just again object to this line of questioning? I thought that we had dealt with this previously when both my learned friend and I had engaged through you, Chair, on this very issue. The counsel for the affected members are repeatedly asking Mr. Kraso about intent and willfulness and what his views are and whether it falls within his purview to make such a determination or to advise on whether there has been willfulness. I don't know how many times I must object or how many times Mr. Kraso must say. He's repeatedly said that it does not fall within his purview to advise on contempt or willfulness. It is for this committee to make that determination. And I ask through you, Chair, that you compel my learned friend to move on to the next issue.
Thank you. Advocate, can we move? Even the allocated 15 minutes is already gone, but I'm allowing you. Can we have progress, please?
Thank you, Chairperson. I suppose you've made a ruling without an opportunity for me to respond. Then I must place this on the record. If I'm to progress and move away from this line of questioning, then Mr. Kraso must retract the evidence that my members acted in contempt. If you can make a ruling on that, then Chair.
Sorry, through you, Chair.
Yes, Initiator.
Yes, Mr. Kraso will not retract any of his evidence. I certainly do not recall him saying that the members acted in contempt.
Advocate, can you proceed? You heard the initiator.
Thank you, Chairperson. I will not persist with the line of questioning on the understanding that you never gave such evidence. Because to the best of my recollection, you were asked, what do you make of the behavior of my clients? And to the best of my recollection, your response was they acted in breach and they defied the speaker. You might not have used the word, and if I can just conclude the point, please. If I can just make the point that it doesn't have to be the word contempt that's being used, but if the conclusion is that there's contemptuous conduct by my members, then I must take you up on that conclusion. But if you're saying that was not your testimony, then I accept that for what it is, and then I'll move on. Do you understand?
Chairperson,
Chairperson, sorry, before Mr. Kaso responds, may I respond?
Yes, do so.
Yes, thank you. And I object to that very firmly. With respect to my learned friend, it's a nonsensical proposition that he is putting to Mr. Kaso. That even if Mr. Kaso did not use the word contempt or express himself, whether the conduct of the affected members were contemptuous of Parliament, but yet it can be inferred from what he said, then I strongly object to that. That is plainly two different legal concepts. And contempt is a legal concept that this committee must determine. Thank you, Chair.
Thank you, Initiator. Advocate, assist us because the responsibility of the committee is to do what you are asking Mr. Kaso. Can you ask him on evidence given yesterday based on the footage and the videos which we saw? Issues which relates to judgment should rest with the committee. So I'm requesting that do not subject him to that. Is the responsibility of this committee to do that. Your 15 minutes is gone. I'm now giving you another 10 minutes. Let us proceed.
Thank you, Chairperson. Mr. Kaso, did my clients breach the rules as a general proposition without getting into detail?
The members did breach the rules.
Did my members act contemptuously of the House? Yes or no?
This committee will make that determination. I can make that determination.
Thank you. Let's move to another aspect. You obviously testified that you advise this House on procedure and the rules, and I won't ask you to confirm. You've confirmed at least 3 times. And it is a structure of this House that must make a determination as to whether my clients acted contemptuously or not. Not so.
Yes.
And it is the structure of a House you advise or the Parliament you advise that must decide whether to accept your evidence or not. Not so.
Yes, it is. Yes.
I would suggest, given that position, that the structure of this Parliament, which you advise, must make a determination about the quality of evidence, is untenable as a matter of principle, isn't it?
May I listen to that question again, Chairperson?
I think the initiator wants to come in. I'll allow her the opportunity.
No, if my learned friend could just repeat that, please. Thank you.
I'll repeat. You advise this Parliament on the questions of procedure and the rules. We've established that.
Yes, Chairperson.
It is a structure of this Parliament, being this committee, that must decide the credibility, the merits and the demerits of your evidence, isn't it?
Yes, it is the structure.
It's the same structure that falls under the bigger body being Parliament that you advise, isn't it?
Yes, it is.
I'm putting a proposition to you now. That is untenable, isn't it?
I don't think it is untenable.
Very
Madam-
well. I will not belabor the point. I see the initiator wants to come in.
Thank you, Madam Chair. May I just raise an
Yes,
issue?
Yes.
Thank you. Thank you. I think that it's a legal proposition and it's an argumentative proposition that my learned friend is putting to Mr. Kaso, which is best kept and which is appropriate for legal argument. Thank you.
Advocate, can you align yourselves with what your learned friend is saying and assist the committee by cross-examining the witness because we are benefiting from those arguments. Thank you.
Very well, Chairperson. What I would have said, and I will not ask to question you on it, I want to place it on record because I can preempt what the response will be. I'm putting it on the record because I think this is an appropriate space to raise the issue, and I will not invite your comment because it's along the same lines. But I want to place it on record that it is equally untenable that a structure of this parliament appoints through the state attorney and initiator to prosecute members of parliament, calls a witness who advises this very same parliament, and then ultimately the very structure that they advise then makes a conclusion on your evidence. I'm suggesting that the irregularity extends beyond just you, but the manner in which the initiation process itself runs. I want to place that on the record. I'll move on from that. The last point I want to raise is this, and with your indulgence, Chair, I'm not sure if my 10 minutes are up or not, but I will be done. This is my last line of cross-examination. If I can just take you to the charge, the willfulness charge. It's charge 1. Is this Gaza or this is Gaza? If you have a regard to charge 1 at 247, that's paginated bundle. And it's charge 1. I'll read it. The initiator read it yesterday. And they always say, if you want to be great, you follow the steps of those who are greater than you. The initiator would have read this. I'll read this as well. And hopefully I can follow her in greatness as well. I'll read it again. It is alleged that you are guilty of conduct constituting contempt of parliament in terms of section 13A, C, and D of the Act, and that the member of parliament, and during the sitting of the National Assembly on 30 August 2022, you contravened section 7A and B of the Act read with the National Assembly rules in relation to those subsections, when during the proceedings you inter alia willfully and intentionally failed and or refused to comply with an instruction the speaker to leave the National Assembly. Let's have reference to Mentors 1 if you can, please.
I didn't get the last point.
No, I was talking to my attorney. I'll get back to you just now. I won't read the entirety of it, but it reads verbatim in relation to Gaza and to Mente, that during the proceedings inter alia you willfully and intentionally failed and or refused to comply with the instruction of the speaker to leave the National Assembly. The point is this, Mr. Gaso. I do not know what to make of the evidence you gave in chief in relation to why these two members were instructed to leave the house. But as I understand the charge sheet, they were being charged for failing to leave the house. Not so.
Comply with an instruction by the speaker to leave the house. Yes.
All you've done is rephrase my question to you. I want to phrase it the way I'm phrasing it. If you don't understand it, ask me to repeat it. Don't change the nature of my question.
Chairperson, I am trying to be as faithful to the charge sheet as possible because I believe that is what the advocate is asking me to respond to. The charge sheet says, refuse to comply with an instruction by the speaker to leave the assembly.
Yes, and that's the point I'm simply making, that they were told to leave the assembly and they failed to comply with that instruction, not so.
Yes.
Yes. And I'm saying to you, in relation to Mente at least, this step would not have happened. In other words, she would not have refused to leave had she not been asked to leave, not so.
Madam Chair, sorry, I don't understand the question.
Advocate, can you clarify the question?
Indeed, Chairperson. I am saying Ms. Mente would not have refused to leave the house without being asked to leave the house.
Yes,
And you can only leave the house if you're being directed by the speaker to leave the house.
under this circumstance. Because let me just explain why I say that. Members come in and go out of the house at any point. But under these circumstances, you are supposed to leave the house when directed by the speaker to leave the house. Yes.
So Mente can't have left the house without being asked to leave the house by the speaker.
Yes.
Yes. And I'm saying to you, the speaker can only ask a member to leave the house lawfully, not so.
The speaker can only ask the member to leave the house when the member, according to the speaker, has breached a rule.
So the speaker can't ask someone to leave the house without legal basis. That's what I'm getting at.
Chairperson, the point I want to make is that the speaker makes a determination for a member to leave the house when the speaker believes the member has breached the rules of the house.
And the speaker can't exercise that power unlawfully.
Speaker does not.
Sorry, Madam Chair.
Yes, initiator.
May I speak? Thank you. Again, my learned friend is trying to extract from Mr. Caso a legal proposition which is best left for legal argument. The purpose of which... Thank you, Chair.
Advocate, can you assist us along those lines? We're still coming there, please.
Thank you, Chairperson. I understand the ruling to be I shouldn't proceed along these lines because there was objection, and I will not proceed on these lines because I was ruled to not do so. The final remark is this then, Chairperson. Perhaps it's not a remark, it's an invitation to Mr. Caso. And thank you for taking my questions and being patient with me. I'm inviting you the same way you were invited by the initiator to respond to this proposition, that it's not a question of asking you to draw a legal conclusion, but in light of your seniority, and as I understand it, you've been in this parliament since 1994, which is quite a distinctive achievement. And therefore, I'll take your opinion, and I hope this committee is going to take your opinion earnestly. In light of all the objections that we've raised, the conflicts that I think we've raised, which will substantiate an argument, would you, being invited to give advice as it is within your province, agree with me that there's certainly a bit to be done in terms of the rules of parliament if the object and the project of constitutionally exercising public powers by this parliament is to be taken seriously? Is there something to be done about the rules to ensure the impartiality that we spoke about, mitigating against usage of public power to target political opponents using the rules, and introducing an element of independence in these procedures? Would you agree with me that is something to look into without you expanding? But if you insist on expanding, you can. And I will have no further questions, Chairperson. And I thank you, Chair, and I thank you, this House, for the opportunity. Thank you, Mr. Caso.
Chair, sorry, before Mr. Caso responds, if I may, through you, this is not an
Yes.
appropriate question. This is not an appropriate question for Mr. Caso or for this hearing. This hearing has been convened to test and to prosecute certain charges against the affected EFF members. The issue, or the legal issue for determination, which my learned friend raised with Mr. Caso, was the subject of the High Court interdict application, which, as we know, was dismissed, and which is still part of the Part B review application, which is pending before the High Court for determination. And it's best left for that forum to deal with this issue. Thank you, Chair.
Thank you, Initiator. Thank you, Advocate. Thanks, Mr. Kaso. Thanks, honorable members. We'll now proceed. It's 11:15. I will now invite the initiator to do to cross-examine the witness. I'm giving you 15 minutes. Initiator.
Thank you, Madam Chair. I just have two issues that I want to re-examine Mr. Kaso on. It's hopefully very straightforward. Mr. Kaso, the first issue is if a member takes issue with a ruling that the speaker has made, what is that member's remedy in terms of the rules?
Chairperson, I would like to go to Rule 92 of the Rules of the National Assembly, the 9th edition. Sub-Rule 11 says, the presiding officer's ruling on a point of order is final and binding and may not be challenged or questioned in the House. I think that's the first point of emphasis, in the House. Sub-Rule 12 says, a member who is aggrieved by a presiding officer's ruling on a point of order may subsequently, in writing to the Speaker, request that the principle or subject matter of the ruling be referred to the Rules Committee. So that is the platform available to members. Write to the Speaker, and the matter is then referred to the Rules Committee.
And then may I also just ask for your comment in terms of rule, if I'm not mistaken, 8. That deals, you've just raised the issue with regards to points of order. I now want to go to the issue of general rulings, because the Speaker obviously makes rulings that is not just related to points of order. She may rule on other issues. What is the remedy then?
Rule 8, you said?
Yes.
Well, firstly, I must just read Rule 8 so that hopefully I'll be able to answer your point there. That the Speaker must perform the functions as provided for in these rules and may make rulings in applying and interpreting these rules, orders of the House, and directives. And let me go to point 3. Members must comply with rulings made by the presiding officer. A member may request that the ruling be referred to the Rules Committee for consideration and report, which is basically what I've referred to just now. Thanks.
Thank you. And then just the last issue, I just want to go to the Hansard unrevised transcription relating to Mr. Keza. Can we go to page 340 of Hansard?
I am there, Chairperson.
Thank you. Now, you will recall, Mr. Kaso, that my learned friend cross-examined you on the issue of Mr. Keza not being given an opportunity by the Speaker to raise a point of order. And there was a proposition put to you or a suggestion put to you that the Speaker was unfair to Mr. Keza in that regard.
Yes.
But I want you please just to, with reference to this page, please tell the committee what immediately preceded the Speaker's instruction to Honorable Keza for him to leave the House.
Chairperson,
If one goes to the top of page, well, to page 340.
yes. Page 240, but even before page 240, just looking through from page 338, there was a matter raised by Honorable Shivambu about people migrating to Namibia and the issue of Phala Phala, basically. And the speaker, even before this, had said a question on Phala Phala is coming. I may just state again for the record, there were 6 questions that day. There was a question on question on migration, which was question number 1. There was a question on GBV, which was question number 2. There was a question on issues of security and uprisings. And then there was a question on issues of social ills. And there was a question on Phala Phala, which was question number 5 on the day. So Speaker kept saying this thing. So before Honorable Xeza spoke, Speaker had made a point that this point has been dealt with and is going to come. In other words, she had ruled on the issue and the issue was going to come later. Now, Honorable Xeza then speaks unrecognized by the Speaker. And I won't read what unless you would want me to read. It's in page 340.
If you could just read perhaps for the record what Mr. Xeza says about Phala Phala.
He must respond to the issues pertaining to the abuse and the abduction of women in Phala Phala farm. That is what is at the center of what he should be responding to. Because in a country like this, we cannot, when women are being killed, and the president does that as a first citizen of the country, and you are saying to us, he must not be held accountable. So the point that I was making is that there was a question on Phala Phala, but even before the question on Phala Phala, there was a question that is where I was coming as question number 2, which was dealing with issues of GBV. So we're not at that. So Speaker then says, she then says, Honorable Xeza, will you please leave the House? Honorable Xeza, will you please leave the House? So what you see here, because the rulings of the Speaker are final and members must comply. Speaker had already ruled on the issue and it was final that we're not dealing with Phala Phala now. And it is expected that members must comply with that ruling.
And Mr. Xeza, just to finish off this point, the transcript on page 340, what does it also show? Did the speaker recognize Mr. Xeza, or did Mr. Xeza just speak on his own?
No, he spoke on his own.
Yes. Thank you. Madam Chair, that is the extent of my re-examination. Thank you.
Thank you, Initiator. You were within your time frame. You are left with 8 minutes. We'll take as a bonus. I will request that we adjourn for tea. We'll add your 8 minutes plus 15 minutes, which means we'll resume at 11:45. Thank you.
Thank you.